Hey everybody, this is the Groundwater Law Activity. You're going to use this video and this video will guide you through what you're going to be doing today. So first thing we're going to do is we're going to read the background information. Who owns groundwater? Who has the right to use it? How much can they use? Should they be allowed to change its quality? Can water rights be sold? As with any limited resource, we must have rules and laws to regulate groundwater use and protect its quality. Making groundwater laws is not easy. Courts and lawmakers must consider competing uses, water availability, and water quality. Laws must evolve as uses, availability, and quality change. Groundwater rights involve two separate issues: water use, how much you're going to use, the quantity, and water quality. In other words, is it good, clean water? In Wisconsin, groundwater quality is generally covered by legislative law. Legislative law is created by the state's legislative or administrative process. Legislative laws include constitutions, treaties, statutes, administrative rules, and regulations and ordinances. Groundwater quantity laws, on the other hand, are generally based on common law. Common law is law which is developed through court case decisions. A judge establishes societal values as law by issuing decisions in cases that he or she hears. Common law may change as societal values change. This activity focuses on the evolution of Wisconsin's groundwater's common law. So in other words, as the years go by and as society changes, laws change. And that's all that this is saying. So the next thing we're going to review are the four common doctrines that have ruled groundwater law in the past. Number one is the English rule. Groundwater use is a property right. Under this doctrine, a landowner has the right to use the water under his or her land at any time and for any purpose. The landowner may also sell or allow others to use his or her waters. This rule grew out of the belief that groundwater movement could not be understood and that landowners couldn't anticipate the consequences of pumping groundwater. So what this is saying is that if you own the land, you can do whatever you want with the water underneath it. They didn't really understand how groundwater moved, so they couldn't really make predictions to say that, hey, if you use too much, it's going to affect someone else. They really didn't understand how groundwater worked back in the day. Number two, reasonable use rule. Groundwater use is a property right, but water may only be used for reasonable purposes. A property owner may use the water on the land from which it came or elsewhere, as long as his or her use is reasonable in comparison to the water needs and uses of his neighbors. So again, saying that, okay, the groundwater is a property right. I can use the water for whatever I want as long as it's reasonable, and it's got to be reasonable compared to our neighbors. So if they wanted to water for something that really wasn't reasonable, you had the right to it. But if you were doing something that was highly unreasonable and it impacted the neighbors, no, you didn't have the right to do that. Correlative rights rule. All landowners in an area have a right to use groundwater. The amount of water each landowner can use depends on the amount of land he or she owns. The landowner cannot pump more than his or her share of water, even for use on his or her own land if other water users don't have enough water to meet their needs. So it's basically you get equal amounts, but if you have more land, you can use as much water relative to the amount of land that you own. So if I had twice as much land as you, I can use twice as much water as you. And then the appropriation rule, sometimes called the rule of first in time, first in right. Groundwater rights under this doctrine are not connected to land ownership. A person has a right to use the groundwater if he or she has obtained it and put it to a beneficial use such as irrigation, mining, manufacturing, power generation, raising fish, watering farm animals, household or recreational uses. Water use may be assigned priority. Water may be used on the land from which it came or from elsewhere. appropriations rights might be sold or given to others. So under this doctrine, in times of water shortages, those who have used the water the longest may use all the water they have used in the past, and newcomers may be left with little or no water. If a person stops using his share of water for a beneficial purpose, he or she may lose the right to use the water at all. So in other words, it's kind of like if you snooze, you lose. If you're using the water first, you have that continued right. And if other people come behind you or after you and they want to use it, you can continue to use as much water as you've always used. And so if more and more and more and more people want to use it and all of a sudden there's not enough, they have to stop because you have the right to continue using the water that you've always used. But like it says here, if all of a sudden you stop using it for a number of years and then you want to start using it again, you may not have that right anymore because now all of a sudden you gave up first in time because someone else is in the front of the line. So what you're going to do next is you're going to take a look at a Wisconsin court case. And you're going to have to answer some basic questions about it. And this case is called Huber versus Merkel, Wisconsin Supreme Court, 1903. So in 1903, a decision was made in the Wisconsin Supreme Court that influenced groundwater law for more than 70 years. So if you can think about it, 1903 to 1973, all groundwater decisions in Wisconsin were based on this court case. So in 1903, a decision was made in the Wisconsin Supreme Court that influenced groundwater law for more than 70 years. This case involved two farmers, Mr. Huber and Mr. Merkel, who lived about 1/2 mile from each other. Both farmers owned flowing artesian wells. Mr. Merkel had two wells on his property. One was dug in 1899 and the other in 1900. Mr. Merkel used some of his water for a fish pond and some he sold to neighbors. Mr. Huber, like other landowners in the area, capped his well so that the water would not flow out when he was not using it. Mr. Huber's well was dug in 1899, and his farm is 20 feet higher than Mr. Merkel's. So this is going to start to come into play. If we're starting to look at when they dug it, so they both dug it in 1899. But look, Mr. Merkel's farm is not as high because it says Mr. Huber's farm is 20 feet higher than Mr. Merkel's. And we've been talking about how groundwater flows from higher to lower elevations. So this may come into play later on. There was enough water for both farmers' and neighbors' homes until Mr. Merkel began letting his water flow freely, maliciously wasting water to harm his neighbors. When Mr. Merkel's wells were allowed to flow, water levels dropped in all neighboring wells, and some of the wells stopped flowing. Mr. Huber took Mr. Merkel to court to try to stop him from wasting water from his artesian well. So again, Mr. Huber's was 20 feet higher than Mr. Merkel. And then what happened? Mr. Merkel began letting his water flow freely. And so if Mr. Huber's well was higher, he basically drained down or lowered the aquifer, the water table, to the point where some people couldn't use it anymore. And that's why Mr. Huber took Mr. Merkel to court. The case fought all the way to the Wisconsin Supreme Court. In 1903, the Supreme Court decided that the English rule used in Wisconsin at the time meant that a landowner had an absolute property right to use water under his or her property. Since Mr. Merkel had an absolute right to use groundwater under his property, he could consume, sell, or even waste water from his well if he wanted. So Mr. Merkel won the case, and Mr. Huber's probably had to find a way to pump water from his once flowing artesian well. So he could still get water. He just had to figure out how to pump it and how to get it out of the ground. So again, they used the English rule. And if we back up, remember the English rule basically said, if the water's underneath your land, you have an absolute right to it. You can do whatever you want with it. If you want to just let it flow, because that's what you could do under the English rule. So again, in 1903, Mr. Merkel won the case, and Mr. Huber probably had to find a way to pump water from his once flowing artesian well. So again, Mr. Merkel won. As you can probably imagine, the 1903 decision was heavily criticized, but the English rule stood until 1974 when the state took Michael's pipeline construction incorporated to court for harming local wells and building foundations when they dewatered soil for construction of a sewage pipeline. So again, this held until 1974. Then the state of Wisconsin took Michael's pipeline construction to court, saying that they were harming local wells because they were dewatering the soil. In other words, they were taking the saturated soil and they were lowering it so they could dewater it. So they lowered the water table. Groundwater use is still considered a property right under Wisconsin's modified reasonable use rule, but a landowner may withdraw and use groundwater only for beneficial purposes and only if pumping does not cause unreasonable harm to his or her neighbors. Unreasonable harm includes lowering the water table, reducing artesian pressure, and direct effects on water levels of streams and lakes. So, 1974, the state of Wisconsin stopped using the English rule, and they came up and they started using Wisconsin's modified reasonable use rule. A landowner may pump water from his or her land and use it for any beneficial purpose unless A, pumping water causes unreasonable harm to someone else by lowering the water table, or B, pumping has a direct and substantial effect on lakes, streams, and wetlands. And remember, we talked about this. The top of lakes, the tops of streams are basically the water table. So if you lower the water table, lakes are going to be lower, lakes may not exist anymore, streams may not flow anymore, and then wetlands may dry up and not be wetlands anymore. So the court has to determine what is unreasonable harm or direct and substantial effect on a lake to a stream. So if you were to take anybody to court today for this, you would have to prove that they were causing unreasonable harm to you or direct and substantially affecting a lake or a stream. So what you're going to do now is you're going to answer these questions here. And then we're going to go over these in a few minutes. So the first question, why did Mr. Huber take Mr. Merkel to court? So back up the recording if you want, or reread, or you can use it from memory. Why did Mr. Huber take Mr. Merkel to court? Second question, what is a flowing artesian well? Remember, we talked about artesian wells in class, plus you can look up above. 3, how did Mr. Merkel's action affect neighboring wells? 4, what did the state Supreme Court decide in this case? 5, on what groundwater doctrine was the court's decision originally based? Hint, hint, let's think of the English. And then here's the climax of the whole thing. We're going to see what you've learned. So let's go back to 1903. Imagine that you're on the Supreme Court and you are responsible for deciding the Huber versus Merkel case. I want you to write a short paragraph, 3 to 4 sentences. Explain how you would decide the case using Wisconsin's modified reasonable use doctrine. So remember, Mr. Merkel, if we back up, he won the case. And he won the case because they cited and used the English rule. So now, how would you decide the case using Wisconsin's new modified reasonable use rule? So go ahead, write a couple paragraphs, or not a couple paragraphs, 3 to 4 sentences explaining how you would decide the case using this. So go ahead, get started on this. Make sure that you're working hard and make sure that you get this done prior to the end of the hour. Thanks. Bye.